A domain name registrant that wins a case under the UDRP gets to keep its domain name, but occasionally it can also win something else, a finding of reverse domain name hijacking, or RDNH. That's what happened in the case I'm talking about today for the domain name ITDC.com, in which the UDRP panel criticized the complainant for filing a case that was just not supported by appropriate evidence. Hi, it's Doug Isenberg, and reverse domain name hijacking is an uncommon finding in a UDRP case, but it's something that both trademark owners and domain name registrants should be aware of when engaged in a cybersquatting dispute. In this video, I'm going to explain what happened in the ITDC.com case, why the three-member panel issued a finding of RDNH, and what it means for domain name disputes. The UDRP complaint here was filed by a company called HBA Holdings, LLC in January 2021, and the decision was issued about 2.5 months later, a typical timeline for a UDRP case. According to the decision, HBA Holdings said that it acquired rights to a registration for the trademark ITDC from a company called IT Data Consulting, LLC, which owns and operates a website using the domain name it-dc.com. Note that this is not the disputed domain name in the UDRP case, itdc.com without a dash. In any event, the complainant said that the ITDC trademark it obtained was registered in 2019 and had been filed the year before and was for use in connection with information technology consulting services. HBA Holding said that William Sylvester, the registrant of the disputed domain name itdc.com, acquired it only after HBA Holding had obtained its trademark rights, and that Sylvester's purpose in doing so was to use it in connection with the same services as HBA. HBA Holding also said that it sent a demand letter to Sylvester before filing the UDRP complaint, and that Sylvester refused to transfer it. But Sylvester disputed most of this, pointing out that he was an employee of a company called Internet Tool and Die Company, and that he had obtained the itdc.com disputed domain name for almost $15,000 in 2018 as an acronym for his business, which develops Internet Protocol Number Management software for commercial use, and that he had no awareness of HBA Holding when he acquired the domain name. So, on the merits of the UDRP case, here's what happened. Under the first element of the UDRP, the panel found that HBA Holding had rights in the trademark ITDC as a result of the registration it had acquired, and that the disputed domain name itdc.com was identical to that trademark, a very straightforward finding. The panel then skipped over the second element of the UDRP, rights to legitimate interests, and went directly to the third, or bad faith element, and its position was clear from the beginning, when it said that HBA's evidence was lacking in many respects. Among other things, the panel said that it was unclear whether HBA, as opposed to the company from which it acquired the ITDC trademark, had ever actually used the trademark itself. It also said that it was unclear whether HBA had any common law trademark rights when the itdc.com domain name was registered by the respondent. It said that complainant's entire case rests on the notion that complainant has broad prior rights in ITDC, yet complainant had not provided any evidence that ITDC was even a known or established mark in November 2018 when respondent acquired the disputed domain name. It said that Sylvester owns a legitimate business known as Internet Tool and Die Company that is not a competitor with HBA. It said that ITDC is an acronym used by a number of other parties. My own internet research led me right away to the India Tourism Development Corporation. And the panel said that not only had Sylvester rebutted HBA's allegations, but that Sylvester had responded to HBA's demand letter with a detailed response even before the complaint was filed. So in the end, the panel had no difficulty finding that HBA had failed to prove that Sylvester registered or used the domain name in bad faith. rejecting the UDRP complaint and allowing Sylvester to keep the domain name. But Sylvester wasn't satisfied just to win the case. He also asked the panel for a finding of reverse domain name hijacking, or RDNH. The UDRP rules define RDNH as using the policy in bad faith to attempt to deprive a registered domain name holder of a domain name, and says that a panel has the power to declare in its decision that a complaint was brought in bad faith and constitutes an abuse of the administrative proceeding. In the ITDC case, the panel repeatedly criticized the complainant's lack of evidence to support its claims, and that the complaint contained unsubstantiated and conclusory allegations. The panel even went so far as to say that there were several allegations made by the complainant that withheld material facts from the panel, such as previous correspondence between the parties. Here's a bit more of what the panel said. Complainant was or should have been aware that without proof, it lacked rights in ITDC sufficient to succeed in a UDRP proceeding, but was hoping for a default, or that the panel would somehow find otherwise. At best, complainant may now have a trademark infringement or unfair competition claim against Respondent over the registration and use of the disputed domain name, but complainant does not have a viable cybersquatting claim against Respondent based on the evidence in this proceeding. After over 20 years of UDRP jurisprudence, complainant clearly ought to have known that it could not succeed under any fair interpretation of the facts reasonably available prior to the filing of the complaint, and that basing its complaint on the barest of allegations without any supporting evidence on what is essentially a trademark infringement dispute was doomed to fail in an abuse of the UDRP process. And therefore, the panel entered a finding of reverse domain name hijacking because it said HBA had abused the UDRP system. Now, at the end of the day, RDNH does not carry any direct consequences. HBA didn't have to pay any fines or even cover Sylvester's legal fees, and it isn't precluded from using the UDRP process in the future. But it's an embarrassing finding, a kind of public reprimand that all trademark owners should want to avoid. If you want to learn more about the UDRP, please check out my masterclass on domain name disputes, as well as other resources on my GigaLaw website. And be sure to subscribe to the GigaLaw YouTube channel to be notified of future videos discussing other UDRP cases. Thanks for watching, and see you next time online.